Section 144, Division of Powers between General Meeting and Board of Directors. 1. A company shall act through the members of the company in General Meeting or the Board of Directors or through officers or agents, appointed by, or under authority derived from the members in General Meeting or the Board of Directors. 2. Subject to this Act, the respective powers of the members in General Meeting and the Board of Directors may be determined by the Constitution of a company. 3. Except as otherwise provided in the Constitution of a company, the business of the company shall be managed by the Board of Directors, who may exercise the powers of the company that are not by this Act or the Constitution required to be exercised by the members in General Meeting. 4. Unless the Constitution of the company otherwise provides, the Board of Directors, when acting within the powers conferred on them by this Act or the Constitution of the company, are not bound to comply the directions or instructions of the members in General Meeting. 5. Subject to Section 145, the members in General Meeting may a. Act in a matter if the members of the Board of Directors are disqualified or are unable to act by reason of a deadlock on the board or otherwise. b. Institute legal proceedings in the name of and on behalf of the company if the Board of Directors refuse or neglect to do so. c. Ratify or confirm an action taken by the Board of Directors, or d. Make recommendations to the Board of Directors regarding an action to be taken by the Board. 6. An amendment of the Constitution of a company shall not invalidate a prior act of the Board of Directors which would have been valid if that amendment had not been made. Section 145, Major Transactions. 1. A company shall not enter into a major transaction unless the transaction is a. Approved by special resolution, or b. Contingent on approval by special resolution. 2. For the purposes of this section, a. Assets include property of any kind, whether tangible or intangible. b. Major transaction means 1. The acquisition of, or an agreement to acquire, whether contingent or otherwise, assets, the value of which is more than 75% of the value of the assets of the company before the acquisition. Or 2. The disposition of, or an agreement to dispose of, whether contingent or otherwise, assets of the company, the value of which is more than 75% of the value of the assets of the company before the disposition. Or 3. A transaction that has or is likely to have the effect of the company acquiring rights or interest or incurring obligations or liabilities, including contingent liabilities, the value of which is 75% of the value of the assets of the company before the transaction. And c. The assets of the company as regards major transactions under paragraph b include the assets of the company and that of the subsidiaries. 3. The provisions of paragraphs a and b of subsection 2 shall not affect an agreement entered into by a company to give a charge secured over the assets of that company, the value of which is more than 75% of the assets of the company, for the purpose of securing the repayment of money or the performance of an obligation. 4. In assessing the value of a contingent liability for the purposes of subparagraph 3 of paragraph b of subsection 2, the directors a. shall have regard to every circumstance that the directors know, or ought to know, affects, or may affect, the value of the contingent liability. b. May rely on estimates of the contingent liability that are reasonable in the circumstances. And c. May take account of the likelihood of the contingency occurring, and 2. Any claim the company is entitled to make and can reasonably expect to be made to reduce or extinguish the contingent liability. 5. The provisions of this section do not apply to a major transaction entered into by a receiver appointed pursuant to an instrument that creates a charge over the whole of or a substantial part of the property of a company. Section 146, Delegation to Committees and Managing Directors. Except otherwise provided in the Constitution of a company, the Board of Directors may a. Exercise their powers through committees consisting of a member or members of the board as the Board of Directors think fit, and b. From time to time appoint one or more of the members of the board to the office of Managing Director and may delegate all or any of the powers of the Board of Directors to that Managing Director. Section 147, Acts of the Company. 1. An act of the members in General Meeting, of the board of directors, or of a managing director while carrying on in the usual way the business of the company, is the act of the company, and accordingly, the company is criminally and civilly liable for that act to the same extent as if the company were a natural person. 2. For the purposes of subsection 1. A. The company does not incur civil liability to a person if that person had actual knowledge at the time of the transaction in question that the general meeting, board of directors, or managing director, did not have the power to act in the matter or had acted in an irregular manner, or if, having regard to the position with, or relationship to, the company, that person ought to have known of the absence of the power or of the irregularity. Or B. If in fact the business is being carried on by the company shall not escape liability for acts undertaken in connection with the business merely because the business in question was not among the businesses authorized by the constitution of the company. Section 148, Acts of Officers or Agents. 1. Except as provided in Section 147, the acts of an officer or agent of a company are not acts of the company, unless a. The company, acting through the members in general meeting, the board of directors, or managing director, has expressly or impliedly authorized that officer or agent to act in the matter, or b. The company, acting under paragraph A, has represented to the officer or agent as having the authority of the company to act in the matter, in which event the company is civilly liable to a person who has entered into the transaction in reliance on that representation, unless that person had actual knowledge that the officer or agent did not have the authority, or unless, having regard to the position with, or relationship to, the company, that person ought to have known of the absence of authority. 2. The authority of an officer or agent of the company may be conferred before action is taken by that officer or agent or by subsequent ratification. 3. The knowledge of action by that officer or agent and acquiescence in that action by a. The members for the time being entitled to attend general meetings of the company. B. The directors for the time being. Or c. The managing director for the time being, is equivalent to ratification by the members in general meeting, by the board of directors, or by the managing director. 4. This section does not derogate from the vicarious liability of a company for the acts of the employees while acting within the scope of their employment. Section 149. No constructive notice of registered documents. Except as provided in Section 121, regarding particulars in the Register of Particulars of Charges, a person shall not be deemed to have knowledge of any particulars, documents, or the contents of documents by reason only that those particulars or documents are registered by the registrar or referred to in any particulars or documents so registered. Section 150. Presumption of regularity. 1. A person having dealings with a company or with any other person who derives title under the company is entitled to assume that a. The company has been duly incorporated under this Act. B. A person described in the particulars filed with the registrar pursuant to Sections 13 and 216 as a director, managing director or company secretary of the company, or represented by the company, acting through the members in general meeting, board of directors, or managing director, as an officer or agent of the company, has been duly appointed and has authority to exercise the powers and perform the duties customarily exercised or performed by a director, managing director, or company secretary of a company carrying on business of the type carried on by the company or customarily exercised or performed by an officer or agent of the type concerned. C. The company secretary, and any other officer or agent of the company having authority to issue documents or certified copies of documents on behalf of the company has authority to warrant the genuineness of the documents or the accuracy of the copies so issued, or a document has been duly authenticated by the company if it 1. Bears what purports to be the seal of the company attested by what purports to be the signatures of two persons who, in accordance with paragraph B, can be assumed to be a director and the company secretary of the company. Or 2. Is certified by what purports to be the signatures of two directors and the company secretary of the company and those deriving title under the document are stopped from denying the truth of that assumption. 2. For the purposes of subsection 1. A person is not entitled to make any of those assumptions if that person had actual knowledge to the contrary, or if, having regard to the position with, or relationship to, the company, that person ought to have known the contrary. Or B. A person is not entitled to assume that any one or more of the directors of the company has or have been appointed to act as a committee of the board of directors, or that an officer or agent of the company has the authority of the company by reason only that the constitution of the company provides that authority to act in the matter may be delegated to a committee or to an officer or agent. Section 151. Liability of company not affected by fraud or forgery of officer. Where, in accordance with sections 147 to 150, a company would be liable for the acts of an officer or agent, the company is liable although the officer or agent has acted fraudulently or forged a document purporting to be sealed by, or signed on behalf of, the company. Ends here.